Welcome to this YouTube channel. In this video, we are going to talk about politicians' interference in insider trading resulting in slap on hand for them. So before starting this video, please like this video and subscribe to this channel for our future updates. Insider trading is the trading of a public company's stock or other securities, such as bonds or stock options, based on material, non-public information about the company. In various countries, some kinds of trading based on insider information is illegal. This is because it is seen as unfair to other investors who do not have access to the information, as the investor with insider information could potentially make larger profits than a typical investor could make. The rules governing insider trading are complex and vary significantly from country to country. The extent of enforcement also varies from one country to another. The definition of insider in one jurisdiction can be broad, and may cover not only insiders themselves, but also any persons related to them, such as brokers, associates, and even family members. A person who becomes aware of non-public information, and trades on that basis may be guilty of a crime. Trading by specific insiders such as employees, is commonly permitted, as long as it does not rely on material information not in the public domain. Many jurisdictions require that such trading be reported so that the transactions can be monitored. In the United States and several other jurisdictions, trading conducted by corporate offices, key employees, directors, or significant shareholders must be reported to the regulator or publicly disclosed, usually within a few business days of the trade. In these cases, insiders in the United States are required to file a Form 4 with the U.S. Securities and Exchange Commission, SEC, when buying or selling shares of their own companies. The authors of one study claim that illegal insider trading raises the cost of capital for securities issuers, thus decreasing overall economic growth. However, some economists, such as Henry Mann, have argued that insider trading should be allowed and could, in fact, benefit markets. The corporate insider, simply by accepting employment, has undertaken a legal obligation to the shareholders to put the shareholders' interests before their own, in matters related to the corporation. When insiders buy or sell based upon company-owned information, they are said to be violating their obligation to the shareholders. For example, illegal insider trading would occur if the chief executive officer of Company A learned, prior to a public announcement, that Company A will be taken over and then bought shares in Company A, while knowing that the share price would likely rise. In the United States and many other jurisdictions, however, insiders are not just limited to corporate officials and major shareholders, where illegal insider trading is concerned, but can include any individual who trades shares based on material non-public information in violation of some duty of trust. This duty may be imputed, for example, in many jurisdictions, in cases of where a corporate insider tips a friend about non-public information likely to have an effect on the company's share price. The duty the corporate insider owes the company is now imputed to the friend, and the friend violates a duty to the company if he trades on the basis of this information. Liability. Liability for inside trading violations generally cannot be avoided by passing on the information in an "I scratch your back, you scratch mine" or quid pro quo arrangement if the person receiving the information knew, or should have known that the information was material non-public information. In the United States, at least one court has indicated that the insider who releases the non-public information must have done so for an improper purpose. In the case of a person who receives the insider information, called the tippee must also have been aware that the insider released the information for an improper purpose. One commentator has argued that if Company A's CEO did not trade on undisclosed takeover news, but instead passed the information on to his brother-in-law who traded on it, illegal insider trading would still have occurred, albeit by proxy, by passing it on to a non-insider, so Company A's CEO would not get his hands dirty. Misappropriation theory. A newer view of insider trading, the misappropriation theory, is now accepted in U.S. law. It states that anyone who misappropriates material non-public information, and trades on that information in any stock may be guilty of insider trading. This can include elucidating material non-public information from an insider with the intention of trading on it, or passing it on to someone who will. Proof of responsibility. Proving that someone has been responsible for a trade can be difficult, because traders may try to hide behind nominees, offshore companies, and other proxies. The Securities and Exchange Commission, SEC, prosecutes over 50 cases each year, with many being settled administratively out of court. The SEC and several stock exchanges actively monitor trading, looking for suspicious activity. The SEC does not have criminal enforcement authority, but can refer serious matters to the U.S. Attorney's Office for further investigation and prosecution. Trading on information in general. In the United States and most non-European jurisdictions, not all trading on non-public information is illegal insider trading. For example, a person in a restaurant who hears the CEO of Company A, at the next table tell the CFO that the company's profits will be higher than expected and then buys the stock is not guilty of insider trading unless he or she had some closer connection to the company or company offices. However, even where the tippee is not himself an insider, where the tippee knows that the information is non-public and the information is paid for, or the tipper receives a benefit for giving it, then in the broader scope jurisdictions the subsequent trading is illegal. Notwithstanding, information about a tender offer, usually regarding a merger or acquisition, is held to a higher standard. If this type of information is obtained, directly or indirectly, and there is reason to believe it is non-public, there is a duty to disclose it or abstain from trading. In the United States, in addition to civil penalties, the trader may also be subject to criminal prosecution for fraud, or where SEC regulations have been broken, the U.S. Department of Justice, DOJ, may be called to conduct an independent parallel investigation. If the DOJ finds criminal wrongdoing, the department may file criminal charges. It's the kind of controversy that gives further ammunition to those who believe Washington, D.C., is a self-serving swamp that should be drained. As the U.S. economy continues to take a pounding from the coronavirus pandemic, it's emerged that some lawmakers may have parlayed information from private congressional briefings on the threat posed by the virus into potentially lucrative stock trades. If true, it would mean that before the stock market tanked from its all-time highs, and tens of millions of Americans lost their jobs to the ongoing economic lockdown, members of Congress took privileged information on the impending damage, and used it to enrich themselves, in effect, an act of insider trading. Two senators, in particular North Carolina Senator Richard Burr and Georgia Senator Kelly Loeffler, have drawn more attention due to the size and nature of stock transactions made in their names. While both lawmakers have denied the allegations, both the Department of Justice and the Securities and Exchange Commission (SEC) are reportedly investigating whether there was any wrongdoing. Spokespeople for the Justice Department, the SEC, Burr, and Loeffler all declined to comment. Should authorities uncover misconduct, it could prove the biggest test to date for the Stop Trading on Congressional Knowledge Act. Better known as the Stock Act, the law has seldom been put to action since President Obama signed it into effect 8 years ago. While it was theoretically possible to pursue insider trading cases against members of Congress before the Stock Act, such cases were difficult to bring, adds Barak Cohen, a partner at law firm Perkins Coie and a former Department of Justice prosecutor. The Stock Act made it clear that there's a fiduciary duty that members of Congress owe with respect to material, non-public information, and makes it possible to bring those kinds of insider trading cases, Cohen notes. The Stock Act's effectiveness as a piece of legislation remains up for debate, both in terms of preventing members of Congress from unduly profiting from their positions, and also protecting legislators from legal liabilities that could see them unfairly end up in hot water. For some observers, the simplest way to deal with the entire matter is to prohibit members of Congress from owning individual stocks in the first place, and, instead, restrict them to holding investments in broad-based mutual funds and exchange-traded funds. Loeffler announced her intention to do just that earlier this month, in response to the uproar over her stock trades. Painter notes that statutes prohibiting such conflicts for executive branch employees already exist. Under Title 18 Section 208 of the United States Code, it is a criminal offense for members of the executive branch, except for the President and Vice President, to participate in government matters in which they, or their immediate family, has a financial interest. That's why I told former Goldman Sachs CEO, Hank Paulson, that he had to sell his Goldman Sachs stock to become Treasury Secretary. In 2006, Painter recalls of his time as the Bush administration's chief ethics lawyer. But in addition to exempting the President and Vice President, he adds, the law also doesn't apply to members of Congress. In order to comply with 18 U.S. Code 208, as it's more commonly known, many executive branch members place their assets, including stock holdings, in a blind trust. While Loeffler claims to have had no knowledge of the stock trades made on her behalf by investment managers, her holdings are not in a blind trust, an arrangement in which she would have no way of knowing or intervening in how her assets are being managed. My advice to clients is typically, if they're in office or in a position where these laws apply, that a blind trust is an excellent way to protect themselves from liability, Perkins Coie Cohen says. but blind trusts to come with a stigma. The general thinking is that blind trusts don't tend to be invested very well, Covington's Kellner notes. There aren't many people comfortable with the idea of having no idea what risks they are exposed to. What do you think of our video? Which video you want to see next? Let me know in the comment section below. If you enjoyed this video and want to hear from me again, be sure to hit that subscribe button before you go.